Good morning, Mr. Chavez. We are live once you're ready to get started.
Great. Good morning, folks. How are you all?
Doing well. How are you?
I'm well, thank you. Okay, so it looks like we have everybody here, court reporter, counsel. Good morning. The appellants are here. Let's get started. My name is Stephen Chavez. I'm the land use hearing officer for the city of Albuquerque. Today's date is July 7th, 2021. And we are here for a time-sensitive quasi-judicial administrative appeal from the Landmarks Commission, and the appeal number is AC-21-8. I will note that a record of this hearing will be made by our court reporter, and Miss Marin, I did receive a 46-page supplement, and then another supplement to that supplement with apparently some corrections with some addresses. I will include that into the record. Are there any other preliminary matters that we need to take care of before we get started with the merits?
Yes, hearing officer, I would like to use a PowerPoint presentation, and the evidence contained within it is just clarification evidence, additional photos, and some things that were already included in the supplemental packet.
Okay, and just for our record, this is with Katie Marin, and you are an attorney licensed to practice law in the state of New Mexico. The appellants are here. Do you anticipate the appellants testifying in this hearing?
I do not anticipate them testifying unless you have questions for them or some kind of factual issues come up, then they are prepared to testify to that.
Okay, just be aware that I will have to swear them in before they speak. And anybody else that testifies, I'll swear in as well. So please remind me if I do forget. Okay?
Thank you.
Okay, well, let's get started. You have all the time you need. I may politely interrupt you and ask questions if you will allow me to do that.
Absolutely. Am I free to share my screen?
Mr. Moya, can counsel share her screen?
I think we're in.
Yes, there she goes.
Thank you, sir. Go ahead. I can see your screen now.
Perfect. Okay. So just as a background, which you already know, we are here today to appeal the final decision of the Landmarks Commission from the hearing on April 14th, 2021. We're specifically appealing the decisions numbers 3, 5, and 6. As you are aware, the property at issue is a contributing property to the historic district. And I'm going to uniformly refer to the Huning Highlands Historic District in this presentation as just the historic district for the record. To be very clear, we are not here today to argue that historic value is of no significance. To the contrary, historic homes have immense cultural value, which the appellant and his wife recognize. And the purpose of the Landmarks Commission, as we know, is to uphold these standards. That said, the character of the historic district has substantially changed, such that it would be unjust to selectively enforce these regulations against Mr. Mercer. So therefore, the decision of the Landmarks Commission should be overturned as to these 3 points. And I'm going to go over these in detail, but the first one, number 3, pertains to the wood shingle siding on the porch and columns. They want that changed. They want the columns reinstated in the home. And to go back here, you can see this is a picture of the home taken in 2015.
Correct me if I'm wrong, counsel, but it seems to me that in the appeal, as well as in front of the Landmarks Commission, the appellants, or at least one of the appellants, stipulated that the columns were something that they were going to change.
That was something that had been considered, but that is now something that is being appealed based on the arbitrariness of the decision.
Okay.
And also to add, it was included in the response from staff at the Landmarks Commission that it was an unsubstantiated claim that the property was moved. This property, contributing property at 400 Arno Street, was originally built in 1910 on 411 Silver and was in the 1980s after the historic district was created, moved to 400 Arno Street, which I think is important for the record to show that this house was not originally on that corner lot of Lead and Arno. And just by way of background, the house was purchased in 2015 by Mr. Mercer in a severely dilapidated state. You can see on the left picture the laminate floors. He tried to restore those floors by pulling up the laminate, putting in the original wood. These are people who love the neighborhood and loved the character of the home. And even at one point, you can see behind Mr. Mercer in the picture on the right, this is in the bathroom. The house had, by its previous owners, had the windows sealed up and covered. They were able to pull that out and uncover the where the original window had been in the house.
Are you going to include these photographs in the record? They're not in the record now.
They're not in the record, no. They're just talking about the appellants and who they are as far as what they've done on that property. But I can send you this presentation to include in the record if you would like.
Let's do that, because I would like the city council to have as much information as possible. And certainly send your presentation to the city council clerk, Crystal Ortega, and they will forward it to me, and then we will include it into the record. Okay.
Okay, absolutely, we can do that. And here you can see these are the changes of the house. So I think it's important to note right now that the Landmarks Commission is wielding immense power as an unelected administrative agency that cannot be taken lightly when considering the state's power here. At the hearing on the appellant's retroactive application, the commissioners were more than displeased with the actions of Mr. Mercer. And this came through in their discussions about the property and the recommendations. Ms. Brigance testified at the hearing and was asked whether or not she knew she was in a historic district, and couldn't she tell by the houses around her. Repeatedly, the commissioners discussed the neighborhood, which is talking about the neighborhood as a whole and not just this specific property or just the specific properties that are contributing. However,
do these facts go to your argument that you believe the Landmarks Commission retaliated or acted arbitrarily or capriciously? Is that what you're trying to get at?
Yes, hearing officer. These go to the capriciousness and the retaliatory nature of the commissioners, as well as the tone that was at the hearing. If you've had a chance to review the April 14th hearing. However, like when they're talking about the actual character of the neighborhood, these statements are not supported when you're looking at the record as a whole, which hopefully we'll be able to demonstrate here today. But no longer are people who are living in this historic district simply able to look around and tell what is acceptable based on the houses around them. And that's very clear by houses located directly on this same block on Arno Street. So as to final decision number 3, the wood shingle siding on the porch and columns of alternating wide courses. This is what the column looked like underneath once they were able to pull off the particle board siding at the bottom. This was a floating pillar that was supporting the right side of the house and was structurally unstable. This was something that they knew that the house had structural issues, which is why they began to expedite repairs when they understood that the wall at the back of the property appeared to be like a floating wall that wasn't structurally stable. And then they also found out that the column in the front, this is exactly what it looked like when they pulled it off. It's floating off the ground and yet it's supporting the roof. And these columns.
May I interrupt you?
Absolutely.
Just foundation for the photograph. When was the photograph taken?
This photograph, and appellant can correct me if this is wrong, was taken in August 2020.
Okay, so this photograph was taken when the work had begun on the exterior of the
Yes, after they had pulled off the siding at the bottom, then they realized that the pillar was structurally unstable and floating.
Okay, thank you.
As to final decision number 3, there's no clear evidence that the columns were original to the property. So it's unclear why the Landmarks Commission is making this a sticking point when there's no substantial evidence here to base this recommendation on. The commissioners did not have any evidence on point yet went forward with this recommendation to reinstate the pillars when they didn't know if this was a part of the original structure of the house. In fact, one commissioner in particular stated she suspected that these were not part of the original house because this style of pillar was seen around the 1920s. And I haven't seen any evidence to the contrary that these pillars were part of the original house. I haven't seen a picture of the house from any or sketch from 1910.
Isn't the issue though not whether or not those shingles were original to 1910, but whether or not those shingles were original or in an existing condition, and then they replaced them with something that does not appear to look the same. I mean, the issue under the guidelines deals with changing the deterioration so that they will again match what was there before. I thought that's what the guidelines essentially more than recommend.
For this point, I'm not yet talking about the siding of the property, but merely the requirement to reinstate the columns.
I see. Okay.
So this is just about the fact that the commissioners wanted the columns reinstated based on no evidence that the columns were original to the property. As far as the siding of the property, I will discuss that specifically later.
Well, it seems to me that my statement goes to the columns as well. The columns were taken out entirely, and when you say reinstated, they are essentially, I thought that the commission was arguing that the columns should be put in the condition or the appearance that they were in before they were taken away. So I mean, they don't have to put them back together in the deteriorated condition. They have to replace them with like materials, correct? I mean, and it seems to me they specifically agreed to do that.
They are the commission recommended that the columns be reinstated, but as particular to the columns, not like putting the old columns back in, but rebuilding new columns that were similar to the old columns. But based on no evidence, would they require that these be rebuilt because there's no evidence that these were part of the original structure of the house, that these are just added on.
I see. Okay.
So for final decision number 5, originally this is talking about the windows here, and appellants had been working with the senior planner to come to an agreement about the windows, and there had been discussions about just doing the frontward facing windows of the property. So originally the senior planner had recommended the front facing windows on the property be changed and to add metal clad wood facing windows with the 4/1 design that was on the original house.
And that recommendation was based on the fact that those windows were more, I suppose, were more recognizable when you drive on Arno or on lead, correct? The other windows you couldn't really see. So it was basically for appearances.
Correct. There's the guidelines don't typically permit necessarily for people to have vinyl windows. But throughout this neighborhood, there are homes with windows that are very similar to these in historic homes. And so to say that this house is a blot on the neighborhood because of these windows goes against the actual homes in the neighborhood.
Is that why you provided the supplemental photographs of the homes in the neighborhood?
Yes, those supplemental photographs show historic homes, not just new homes with vinyl windows, because I think that's important to note here for the overall character of what's being asked specifically of Mr. Mercer and Ms. Bergantz. And as far as these windows, this is when the retaliatory capricious nature of the commission really starts to shine through, is because there was an extreme emphasis at the hearing on form over substance. Commissioners were very upset that Mr. Mercer had failed to follow proper protocol. Mr. Mercer now recognizes he absolutely should have gone through the proper channels. That said, when the commissioners were looking at the house, they should have looked at it from if Mr. Mercer had submitted the application beforehand, would they have let this in? And I think based on the houses in the neighborhood, they absolutely should have. It would be unjust to selectively enforce these regulations against Mr. Mercer and not do so uniformly in the neighborhood.
But I get that argument. My concern is that the photographs of the neighboring homes that do have vinyl windows, I assume that they're contributing homes. So let's just assume for the moment they're contributing homes. However, we don't know when those vinyl windows were put in. They could have been put in before 2010. And if they were put in before 2010, that was before the guidelines went into effect. And so before the guidelines in 2010, there was no consistency. And in fact, the guidelines specifically state that the reason why these guidelines are being put into effect is because we want consistency with how historic homes are going to be restored. And so if you can show me that those windows with vinyl, those homes with vinyl windows were restored to vinyl windows after 2010, I think you would have a viable argument. But unless you can show me that evidence, I can't see how I can't make that leap of faith.
I don't have the specific years before me right now, but I'm sure that with like searches on Google, I could easily supply that to you today and for it to be added into the record. But I
don't mind giving you 3 days for that. I think that's fair, because I think it's necessary evidence if you can show me, because I get your argument, and I want you to be able to make that argument. It certainly helps me with letting the city council know the basis of the argument and whether or not I believe that argument is viable. But without knowing the year of those changes, I just can't buy into it.
Right, absolutely. The only ones I know for certain that are, just because of my own time in Albuquerque and in this neighborhood, know that the newer builds, of course, have the vinyl windows, and that's what they're permitted to do, which is still failing to put people who live in the neighborhood on constructive notice. If they move to the neighborhood and they see all these homes with vinyl windows, they're not necessarily able to just discern from looking around, which is what repeatedly the commissioner said. Can't you tell just from looking at the homes around you?
Isn't that why they're supposed to go to the planning department and check? I mean, when they're in an historic district, there are some affirmative duties that homeowners have that are extra. Like any zone change, they have to go to the planning department to obtain permission. And I think that's what the pre-application conference is to determine. I mean,
right. And as for the commission, they want the appellant to replace all of the windows on the property, which from what I can tell, normally you would just replace the front public facing windows. But one of the commissioners said that she would be, and I quote for the record, a hard ass about the decision, and stated, "I don't know why we are trying to give him a break here. I think all the windows should be replaced, that he has just gone ahead and bought vinyl windows and stuck them in thinking he wouldn't get caught." This right here directly speaks to the retaliatory capricious nature, whereas if he would have applied appropriately, he likely would have been able to have vinyl windows on the side of the house, because he shouldn't be punished for having a house that's sitting on a corner lot. And he has a 6-foot wall around the property that was approved. And that approval for the wall took 2 months to go through.
Was that approval from the Landmarks Commission, or was it a variance from the ZHE, the zoning hearing examiner?
It's my understanding that Mr. Mercer went through the Landmarks Commission to have the wall, and they've agreed to stucco the wall as recommended by the Landmarks Commission. They're not arguing that point.
Didn't they agree to stucco the wall when it originally went through the Landmarks Commission, though?
Yes, I don't think there was a specific time frame that they had to stucco the wall. I could be completely wrong on that. That could be.
We don't have that in the record, do we? that approval.
No, there's not the
It's
approval.
just reference from people talking about it.
Absolutely, yes. And so these are the two, well, I guess it's 3 windows, but the 2 sets of windows that if there is to be any recommendation, then these should be the only windows that need to be replaced, as they're the front facing windows on the property, on the street. And then the last.
Can you go back? I'm sorry.
Sure, no, you're fine.
I haven't seen this photograph before, so I just wanted to look at it. So this photograph was taken, I'm assuming, after all the work was completed.
Yes, and this should be in your packet in Exhibit B, the houses of the neighborhood. It's just kind of, yeah, no, it should be in the original. This is an exhibit.
I didn't see that in the original.
It's just, I think, buried.
I saw a portion of that photograph in the original, but not the entire photograph.
Maybe it's not the same exact one. So
go ahead. I'm sorry.
Oh, you're fine. And then the last decision to be discussed would be the exterior siding shall be returned to 4-inch horizontal siding to match the original wood to the extent possible. And so this is the back of the house when the appellant bought it in 2015. I mean, this does not have appropriate siding on it at all. It's thin particle-like board siding. You can see that the insulation is damaged and unworkable and was not providing any insulation for the property, and was one of the key reasons why they discovered that they needed to quickly do the repairs.
When was this photograph taken?
I think this was taken in August 2020.
Okay, so before the work or during the work?
I think this is during the work.
Okay. So the exposed area panels were actually lifted off. I mean, they didn't purchase the home in this condition.
No, they didn't. It had this. So if you see that blue thin particle board material, that was also covering the back of this house, and it was just slapped on here and looks like just nailed together haphazardly.
Yeah, it doesn't, I'm not an expert. I'm a lawyer. I'm not a historian. It looks to me like cheap Home Depot siding.
Yes. And as to the particular siding right here that appellant chose, he chose it based on the guidelines. And
he chose it based on the guidelines?
As far as like the clapboard siding is allowed. The type of siding used is allowed if it's similar in size and dimension. But as far as like the character of the home, it did have the exterior wood, and it was appellant's understanding that if he put the clapboard siding on by just a reading of the guidelines, that he would be keeping with the nature of the property.
Okay.
And so
I guess my question is, counsel, I'm sorry to keep interrupting you.
Oh, please do. You're fine.
I'll give you as much time as you need. But if I don't ask, I tend to forget. So I guess the assumption from your statement that he looked at the guidelines, that one of the appellants looked at the guidelines, is that if he knew the guidelines, if he knew about the guidelines, and he actually examined the guidelines, why didn't he apply? And I'm not saying this in retaliation. I'm saying this because it's the process that's required of everybody. I mean, I don't see how the appellants are being targeted, but it's required of everybody. So if the appellant knew the process, why didn't he just apply? Is it because he thought it would take too long? Is that the argument?
Yes. So from the facts of the case, the house was becoming severely dilapidated. At one point, the insurance company had even canceled the homeowner policy on the house until they started to do some repairs. So they slapped some paint on at that point, and just to please the insurance company, but it was getting to a point that the house had to be fixed. They experienced freezing pipes, I believe, in the winter of 2019. And so appellant engaged in conversations with a contractor who gave him a narrow window of time that said, I can get this done. It's a contractor. that's coming from out of town. And so he was able to do it in a narrow window of time. So appellant jumped on that opportunity thinking to stabilize the property because he wasn't sure if he'd be able to get this work done before winter if he delayed. And when he'd applied for the certificate of appropriateness for the wall, he said he applied on April 26th and didn't get the certificate until June 26th, which is 2 months later. And so he didn't want to delay and wasn't sure to the full extent that since he was taking on these other things, I think exactly what all had to be approved. And so that is why we're in this position now. And
well,
then
I've been a trial lawyer for 25 years. When you said contractor, boy, I hope somebody looks at the contractor.
An agency's action is arbitrary and capricious if it is unreasonable without rational basis when viewed in the light of the whole record. So this is one of the commissioners stating that she can live with the wood siding and even live with some of that pillar and doesn't know if the pillars were originally there. So she was okay with the siding that they'd added to the property, but the other commissioners weren't okay with that siding. And so it's arbitrary as to, it just depends on whose opinion that day is the leading opinion as to whether or not the appellant has to remove all of the siding from his property.
Is it your position that the siding meets the guidelines in the handbook?
It's my position that the guidelines say clapboard and that this is clapboard siding and that it's similar to the original siding because it is horizontal, it's overlapping, it's a similar color, and it doesn't detract from the other houses in the neighborhood. This house does not stick out when you look at the neighborhood as a whole. And another example of the arbitrariness of this proceeding was when the senior planner was talking about what she'd included in the presentation, they noticed that the front steps of the property had been changed. And when she was asked, why didn't she include this? She talked about it's hard to rip out cement. And also the new steps look better than whatever was there before.
It seems to me that that was an equitable decision by in use of her discretion. Certainly she could have told the commission that they should require that cement be ripped out. But it seems to me that she was trying to be equitable in using her discretion under the guidelines.
Yes,
but maybe I'm wrong.
No, you're absolutely right. And we agree with that. But as far as talking about the confusing process and what is permitted and as to what guidelines and based on who is the senior planner at the time, what can get through is changing. There was discussion in the record about a new build directly behind the subject property that does not necessarily fit the character of the neighborhood at all, but it is in a main area on the lead corridor directly behind the subject property. And she said that it went through the proper channels at the time, but it was before her time in the office. So I think before 2000, like that house was built, I want to say in 2015.
Now, I can't consider what you just said because there's no evidence of that, and it's essentially just argument.
Okay, I think that should have been in the emails, but maybe it didn't get included.
Oh, thank you for reminding me. The emails under Exhibit C, your Exhibit C, I couldn't read them.
Okay.
I could read some of them, but some of them I couldn't. Could you provide the city council clerk with a better copy of those emails?
Absolutely.
I think it's the last two emails that I just couldn't, they were so blurry, I couldn't read.
I think that's because they were snipped. And so maybe that.
Understood. If you could find a way to make those more viewable, I appreciate it. Absolutely. And if you could provide that to me within the next 3 days, that'd be wonderful. Okay. Through the city council clerk. I suppose in the same venue you did with the supplement, you just send it to everybody as you did, okay?
Okay, absolutely. And then here we are. So this is properties that are located on Arno Street This is across the street, and like a couple houses down, you can see a 6-foot wall in front of this immaculate historic home. And this is not something that you would is permissible in the neighborhood. And so there's no constructive notice here, as this just goes to the character of the neighborhood has pervasively changed. The guidelines say no 6-foot walls, no cinder block walls that are unstuccoed, but here we can see this huge unstuccoed wall going down the side of the property that's easily visible. I would say it's likely visible from the lead corridor, which has been made a large issue by the commission. And then also in this other photo, since 6-foot fences aren't allowed, the house directly across the street has taken to just leaning dilapidated fence post up against his shorter, I think, 3-foot fence.
Now, wouldn't you agree that the context of that would be important for me to look at? I don't know whether or not the unstuccoed brick wall is in the process as a violation, whether or not it was approved, whether or not it was done illegally. We don't know whether or not the planning department actually gave approval to that, or whether or not there's an inspector that's currently trying to get these folks to meet the guidelines. I don't know any of those facts, so I don't know how I can consider those relevant to your arguments.
I think that these are relevant based on just the commission talking about the character of the neighborhood and what's permitted and what's not.
I don't know if those are permitted, though. I mean, I see that they're there, but many times people don't follow the guidelines, and they go out on their own and do things, which is why we're here in the first place. I don't know if this homeowner or this property owner did the same thing. It doesn't help me with that.
Okay. Here, this is a typo in it, I'm sorry, but this is the property that is sitting directly behind the subject property. You can see it has tons of vinyl windows in it and is a very unusual build. If you're familiar with the historic district, I don't know, except of maybe an apartment unit that has the same design to it.
Is that a designated contributing structure?
This is not. No, this is a new build that also, but when the commission is talking, they're talking about the neighborhood as a whole. And I think that that's very important to recognize, is that whether or not this appellant's property is a blot on the neighborhood, and whether it sticks out like a sore thumb. And it's my assertion that it absolutely does not. And when we look at the historic houses that the Landmarks Commission, they're making a huge deal about Mr. Mercer and how he's detracted from the property. But if he would have just let it sit and rot, nothing would have been done. And the house would have probably fallen down. And that's why we have these new builds coming up, because these historic homes are left to become extremely dilapidated, and then they're demolished, and then new builds come up into the neighborhood. So when we're looking at the value here, like, what is more valuable? Is it to save the home? Is it to let it just deteriorate if you can't afford to make these historic changes? I mean, here we have, it's post literally holding up the front of this house. This house is visible from the lead corridor, and I believe it's on Edith, just up the street. And so all of this is important because the commission is repeatedly talking about how appellant's home is important because it's on the corner lot. If the inspector is driving around, how are they not seeing these properties?
But isn't the issue when you try to correct deterioration? That's when you're pulled into the fold of the guidelines. That home can be left in its deteriorated state until they try and restore it, and then they're pulled into the guidelines.
Correct, but it seems that these guidelines are working against the neighborhood.
There's a perverse effect. I get that those are political questions, and I don't have the authority to say the guidelines no longer can be effective.
Right.
Those are political issues.
Right, but as far as the character of the neighborhood and the decision of the Landmarks Commission, what they're letting in, when they're letting things like this stand, but then punishing homeowners for trying to save their properties from complete deterioration. And this is a property right behind the new build that the whole backside is, the siding is completely deteriorated. And this is easily viewed from the lead corridor as well. This also speaks to the character of the neighborhood and what the Landmarks Commission says it's trying to protect. Here is a house on Edith. Now, it's my understanding, from personal knowledge, this house has been sitting like this since before 2015. It could be much longer than that, up to maybe 10 years or longer. This house doesn't even have windows in some of its, where windows should be. It has plywood and a tarp hanging over the front of it. So this also speaks to the character of the neighborhood and how Appellant's house fits into this neighborhood. And it goes to show that these homes, dilapidated homes, attract criminal activity. This is a well-known thing. East Downtown is already known for having high rates of crime. And Appellant himself had experienced multiple instances of criminal activity on his property. And once he remodeled, he has not been aware of any new instances. So he's making the neighborhood safer. And when we talk about the Landmarks Commission wanting to protect historic homes, this home right here, 520 Arno Street, which is in your supplemental packet with actual details, action was taken on this property in 2008 when they retroactively added vinyl windows, similar to Appellant. They put these vinyl windows in. And since 2009, absolutely nothing has been done to this property. It is becoming a public nuisance. It's vacant.
That's Exhibit I, correct, in your supplement?
This is Exhibit I, has actual documentation about this house, and then pictures of the house are included in Exhibit B.
That's the staff report in Exhibit I.
Yes.
This house.
Exactly. This is one of, if not the oldest house in the historic district. And look at the state of it. Like, so we're talking here, and it's important to talk about the actual reason why the Landmarks Commission was created, was to protect landmarks and to protect the historic district and the properties. But if the Landmarks Commission is enforcing against people who are trying to make their houses safer and better, and then not enforcing against people who are letting their houses rot and fall apart. Here we have vinyl windows. This house is located on 518 Arno Street, which is right by the dilapidated house I just showed you. Here are vinyl windows also on Arno Street, 512. This house is particularly important to this case because look at the extreme modifications that were done. The house on the right and the left are the same property. The brick was covered with stucco. The original wood windows were changed to vinyl windows. We have a vinyl window door. So there were major changes taken to this property. And then here, when we look at the neighborhood as a whole, we have historic homes with vinyl windows and we have new builds, and they blend well together. The Appellant's house does not stick out unusually here. And it would be unjust to uphold the Landmarks decision and selectively enforce against the appellant when so many other houses in this district are of the similar character and design. And that's all I have for this.
Okay. With regard to Exhibit I, the staff report, the purpose of you putting that into the record is, I'm assuming, to show that the Landmarks Commission in 2009 approved a recommendation from a city planner to allow the vinyl windows on that home, correct?
No, the purpose of that was to show that the city is aware of the issues with 520 Arno Street Southeast and has done nothing to protect the property.
Okay.
And so it would be unjust to say that appellant should change his property when they're not protecting the oldest house in the historic district.
Well, when you say protect, what do you believe they're supposed to do to protect these homes? I mean, it's a very broad statement, and I don't quite understand that.
For that, I mean that the purpose is to uphold the historic nature of this community. But when we let these homes fall into a complete state of deterioration where they're not salvageable, then the commission isn't doing its job by not enforcing those codes against these houses and making them maintain their properties.
But isn't that an assumption that I really can't buy into at this time based on the evidence? I mean, you're assuming that all of these homes have been permitted through the Landmarks Commission after 2010, when the guidelines went into effect. I don't know that for a fact. I don't know whether or not I agree with you that there's a presumption that many of, if not all of these, are historic contributing dwellings, except for perhaps one that's a commercial dwelling that looks like, or a commercial building. And then there's an apartment complex that doesn't look like it's contributing. But I grant you that. But to argue that because there are features in these structures that may or may not be in the guidelines from 2010, I don't know when these restorations went into effect, when they were completed, and how they approved. I don't know the details, the context that these restorations followed. I'm not willing to buy into that they're being selective in that, in how the guidelines are enforced. I don't see that here. I apologize. I just don't see that here.
Well, I think that this is not so much about when or that these houses incorporated these vinyl windows. And I want to be clear that the two houses at the bottom on the left are new builds, that those were built in deteriorated lots, and also the commercial building. I can't state for sure the other ones. I know that the top left one in was had, I think, burned down the back of it. So they added all of that, which if you can see here, this is a historic building and has the same siding as what was used by appellant. And so I think that the main thing that this is here is that if appellant had applied before and gotten the certificate of appropriateness, that his siding may have been approved. One of the commissioners said she didn't have a problem with the siding. And so that's what we have to look at, is would it have been approved if he would have applied appropriately? Would he have been allowed to do these things? But as far as when we look at the neighborhood as a whole, is his property offensive? No, it's not.
I get that. I don't see the property as being offensive. But let me ask you about the columns. Because at one time they agreed and clearly stipulated in the record that they would restore the columns and they would put the columns back up, or similar columns. Are they still willing to do that? Is that, you're not appealing that issue, or are you?
Yes, we're appealing. Like if they do incorporate the columns, then it should be their decision because they want to add that back, not because it's required by the Landmarks Commission based on no evidence that the pillars were original. So if they may do it, but it shouldn't be within the year required as the Landmarks Commission, or they may decide not to do it, but it should be their decision since it wasn't an original feature on the house by any evidence.
And how do we know that the columns that were replaced were not original to the, and I guess by original, you're referring to 1910 when the home was built, correct?
Yes, and
Okay.
that's, excuse me, sorry. The appellant doesn't know if they were original to the house because this house was has been moved. The records are unclear, but as far as the commissioners themselves don't know, and based on the architecture of the pillars, they were those unusual, I want to say like buildings, triangular type pillars that were more common in the 1920s and after, as opposed to when this house would have been built, which was 1910.
But doesn't the guidelines really take care of that? Because it seems to me when I saw that argument in the original appeal document that was submitted with the appeal, it seems to me that it doesn't matter if those columns were original to the original build, but they existed from a certain date that meets the historical contributing features of the home. So it's part of the style and the form of the home, and they replaced it. They took it out entirely and replaced it with the 4-inch columns. So isn't there a presumption under the guidelines that the columns need to be restored to some extent?
That was not my understanding based on the discussion at the appeal hearing. It was more of the preferences of the commissioners and what they thought was appropriate.
Okay, got it. Great. Are you finished?
Yes, I can stop sharing.
Okay, thank you. And you will have some rebuttal time, and you can cross-examine any other witnesses that will be testifying. I have questions for the planner. Is she on? Miss Najee.
Yes.
Hello.
Hello.
Najee? Good morning.
Good morning. I don't know if I have my camera open or not.
You do not. I can hear you though.
There I am. Sorry, my computer doesn't work well. Can you hear me?
I can, and I normally don't require planning staff to testify. I like it when staff do testify because it helps me help the city council. So do you plan on testifying today?
I do.
Okay, and you are subject to cross-examination. So please
Sure.
raise your right hand. Do you affirm to tell the truth, the whole truth, and under penalty of perjury?
I do.
Wonderful. Thank you so much.
I don't have any presentation that I wanted to give you. You have everything that I have put together previously. I did get the submittal this morning and was looking over what had been provided in addition. I think the key factors that we have here are that the Landmarks Commission is trying against many odds to maintain the integrity of historic neighborhoods. Huning Highland is a particularly difficult neighborhood because it was always occupied. It has been rental properties for decades. Many of the properties still are rental properties. The lack of care that many landlords have for rental properties is not the greatest. And we do get pushback from people who are in their homes, as with the house that you showed and talked about how negligent the Landmarks Commission was because they wanted them to put in appropriate windows. So the property owner decided, okay, we're not going to do anything. We'll just let the house rot. We do not have the authority. I do not have the authority. The Landmarks Commission does not have the authority to make someone fix their house. We do have the authority to say if someone is fixing their house, they are required to apply for a certificate of appropriateness. If it is minor work, it will be reviewed by me I have 15 days. I usually do it within, depending on how much communication I've had with the applicant, within a couple of days. With COVID, it was a little more difficult trying to email back and forth and back and forth. If it's major work, then it would go to the commission. The applicant has previously applied, has not done all the work that was required. They were required to stucco the wall. They did not stucco the wall. It is realized, I think, anytime you put up a wall that it says to stucco the wall, that you stucco it as you put it up, not 5 years later.
Ms. Najee, let me interrupt you and ask you a question regarding the wall. So the Landmarks Commission approved the 6-foot height from the 3-foot requirement, correct?
I think it's higher than that, but yes, they approved the block wall. Yeah, the 6-foot high block wall.
And did they require, because I don't have the approval document in the record. Do you have a copy of that?
I can send that to you, yes. I did find that.
Please send it to everybody within the next 72 hours. I'd appreciate it. Because I'd like to include that into the record. Now, my question regarding that approval, did the Landmarks Commission specifically require the block wall to be stuccoed?
It did.
Okay.
Because that is a requirement of the guidelines.
Thank you. Okay.
That public-facing walls must be stuccoed. The wall that was between properties is not required to be stuccoed. It does not face the street, the one that was shown in one of the photographs by Ms. Marion. But those that are facing the walls are supposed to be stuccoed. I won't say that everything, some of them were up before the guidelines. And it's a constant battle to make sure that things are done in an appropriate manner. The actions taken by the applicant with this property, when we realized we were notified, I was notified that there was some work going on there. And when I went out there and I spoke with Mr. Mercer, the porch was under construction. And I said, you know, this porch needs to go back the way it was. You know, you need to have the tapered columns and you need to have the shingles. And that's really important for the character of the house. It's so much of a defining feature of the house. Yes, I will do that. And I looked at his contractor and I'm like, you're going to do that, which he didn't speak English, so he didn't know. But, and so we were trying to work through this process to replace just the front windows, to get the porch built the way it had to be rebuilt in the style that it was previously. And then when I went back, you know, a little while later, I found that it had not been built back that way. It had been built back the way that it was. And
when did that first conversation take place? Can you give me a date?
That would have been in August. I think it was in August.
Can you give me a more specific date?
August 2020. But I would be able to find, I have emails. They are in the record in terms of when I first communicated with Mr. Mercer. I think in the letter that was sent in response to the appeal.
Okay. Those are the emails that I couldn't read in the record that are in exhibit. Not the emails from me. The email that you couldn't read, in fact, I would like to request that the applicant, the appellant, include the entire email, because the email that was submitted that you can't really read is from 2 years ago concerning a different property project altogether, when I went back and found that email. And that's why the date's not shown on it and it's cropped out of it. It does not, it's not in regard to this particular action at all. So when that email is provided more clearly, I recommend that you include the actual email and not. Well, Ms. Haji, I'm not going to require the appellants to supplement the record with something you want supplemented. But I will give you the same courtesy that I've given the appellants, and I will give you 72 hours to supplement the record, please, with any emails you think are relevant. So that, and please, again, provide copies to everybody.
Yes, I will do that.
Thank you.
Again, the nature of the guidelines is it talks about replacement should be in like style, dimension, material. Dimension's pretty basic, and that was the whole issue with the siding. We also talk about finish. You know, that hardy board siding comes with like a smooth texture, which is appropriate for historic neighborhoods, and one that makes it look like painted, like rough wood, like you see like wood graining with it, which is what's showing on this, which is not what I would have recommended and told him had he applied. You know, so many of these things would have been solved very easily if you just come and you make the application and I tell you that you're not supposed to close off doorways or close off windows or change the size of window openings, all of which was done. And when the windows are replaced, even if it's not a wood window, you see the nature of the windows that were in the house versus the windows that it were replaced with are smaller, and there's a totally different style of window. And just for point, you know, you showed the appellant showed a house and talking about how they covered over the brick and put in vinyl windows. That house removed like Z-brick that had been glued onto the outside of the house, restoring the original stucco, and rebuilt and refurbished every wood window in that house. So a number of the things.
I'm sorry, you lost me. What are you speaking about?
In the photographs that were shown in terms of the character of the neighborhood and what other people are doing, there was a house that was where it was said that the applicant had covered over the brick with stucco and put in vinyl windows. And I'm just saying, as an example, that house was not a brick house. It was a brick house that had Z-brick glued onto it that was removed with the original stucco repaired, and with every wood window in that house restored back to its original care. There's not one vinyl window in that house.
Now, let me ask you a question. I apologize for, I've been doing this. I always interrupt people, and they lose their train of thought. But if I don't interrupt you, I will lose my train of thought. And so the columns, the argument for not replacing the columns to their original features is that the columns were not constructed when the house was constructed. At least they assume the columns were not, the appellants assume the columns were not constructed when the house was constructed. Is that a relevant issue to determine whether or not the guidelines apply to those columns, or is the issue with regard to original, the term original is regarding the features that existed prior to the restoration efforts? I mean, is there a timeline for that original date?
Not really. The guidelines state, and the national guidelines state that when we look at original, we are talking about to realize that certain changes and additions may be historically significant. This house actually shows up. I did not realize that the house had been moved, so I was quite intrigued because that provided me a lot more information. It still had been originally within the district. But when I went back and looked at the old Sanborn maps, which are a reference that we have to see when things were built, this house actually appeared in 1898. It appeared on the Sanborn maps. And so, but you see that there was a certain change. There was an addition made on to the rear, which is that second bedroom that's in the back of the house. And that was between 1924 and 1931. It was probably during this time when they put the addition onto the back that these tapered columns with the shingles were added to the house. We're talking 70 years ago or 90 years ago that this was done. This is considered historic material. It is definitely a characteristic of the house. You know, the house had always intrigued me. You would go past it, and even though it was dilapidated, it was so cute. And you look at it now, and it's not dilapidated, but it's not cute. It's all the charm has been stripped off of it, and it's like a builder's special from any suburb anywhere. You know, if you want to do that kind of restoration, there's plenty of neighborhoods you can, do that sort of thing too. But in Huning Highland, we are trying to preserve and reinstate and restore a unique historic character that is not found in other parts of the city. And so when you have unique characteristics, it's important for the value of the home, of the neighborhood, to reinstate those qualities. And they certainly are historic, even if they may not have been from 1893 or 1898. That being said, I just feel like so much of this could have been taken care of if he had just applied, and I would have directed him quickly in terms of appropriate material and inappropriate material. I mean, they still have the windows. I think they can restore the windows and reinstate the original windows if that's what they want to do. But what
Ms.
they
Najee,
have there is not.
are you finished? May I ask you some questions? Let me know when you finish.
I'm finished. Thank you. Go ahead.
So do you have the record in front of you by any chance?
I do not,
Okay.
because I'm on vacation.
Well, in the application, the development application, which is on page 173 through 174 of the record, it's the form, the development review application. There is some crossed out words and dates, and then replaced with a red highlighted words and dates. I'm assuming that the city made those changes. For example, the date of the application says 8/21/2020, and then it's crossed out in red, and right next to it in red, it's got a date 2/25/21. And so I'm assuming that it was crossed out because the city, it had misinformation in the application. There was misinformation in the application, or not enough information in the application.
I
Do you know anything
believe,
about that?
I'm not sure about the marking out. I'm trying to pull that up. But initially, the applicant had submitted paperwork when we were talking about doing a certificate of appropriateness minor. When I had talked with him on site, and he had agreed to change the front porch, and we had talked about replacing the windows. But then, before all that information was included, before all that information was included, he had completed the front porch, not doing what there had been an agreement to do, and therefore it needed to be sent to the Landmarks Commission because I wasn't approving what was done.
Okay, and this took place between August 2020 and February 2021, correct? Or am I wrong?
Yes, I mean, it took place, it took time because once we changed, we were slow in getting all the information back from the applicant. I'm here even trying to figure out at what point we had the
application date is, it's got, like I said, it's got two dates. One is August 2020 and the other is February 25th, 2021. Is the actual application date, the correct application date, the February 2021 date?
Yes.
Okay, that's what I thought. That makes sense with the timeline that council has argued. Okay. Now, in your staff report, or let me retract that. In the Landmarks Commission decision, they reference Article 12 of the code, the city ordinances. I assume they're aware, or at least they're now aware, that Article 12 has been incorporated into the IDO and no longer exists. Correct?
Correct. Yes.
Okay. So, and I note that many of the ordinance provisions stated in the decision under Article 12 are actually fairly incorporated into the IDO. Not exactly, though. There are some discrepancies there, and that concerns me. But it looks like the intent of Article 12 is very well referenced and incorporated into the IDOs. Would you agree with that? Is that something you can agree with or no?
Yes, that was certainly the intention when the IDO was written, that it was supposed to incorporate all the information that was in previous ordinances.
I would hate to. I mean, I don't want to remand this back to the Landmarks Commission on that basis, because it seems to me it would be form over substance, or it would be an error that's not significant, because the IDO pretty much incorporates our Article 12. Okay. Is there anything else you would like to add, and you are subject to cross-examination, but before that, is there anything else you would like to add to the record, Ms. Najee?
No, there's not.
I'm sorry, I didn't hear you.
No, there isn't.
Okay. Ms. Marianne, do you have cross-examination questions for Ms. Najee?
Just one. Ms. Najee, you said that you knew that Article 12 was incorporated into the IDO. How do you know that?
Because I was there when it was, when we were going over what goes from the ordinance into the IDO.
And who, you say you were there, what do you mean?
Means I was working for the city at that time, and as we were going over and cross-checking where information needs to be included in the IDO to cover the ordinance of the landmarks ordinance.
And
It was something the department was doing, you know, over a period of years.
Okay, Ms. Najee, hold on. Ms. Marianne, just for your edification, I suppose, if you go to Article 12 in the city ordinances, it'll make reference to the incorporation, which was in 2017.
Okay, I just wanted to make sure that how she found out was in the record.
Got it, understood.
I have no further questions. Thank you, Ms. Najee.
Welcome.
Great. Okay, Ms. Marion, let me ask, but I don't always do this, but it seems to me there might be some wiggle room here. Is there any room for agreement between the appellants and the city? Now, I understand we wouldn't be able to work out a negotiated or a mediation because the Landmarks Commission is involved, but I'm just wondering if there is any agreement on this, on the facts of this matter regarding what can be done, because it seems to me there are some issues that there can be agreement on. Ms. Najee and Ms. Marion, first, Ms. Marion.
I would say that the front-facing windows can be redone. That's something, but we don't agree that all of the windows of the property should have to be redone. Simply because it comes through in the record as a retaliatory endeavor by the commission, and they're punishing the appellants for living on a corner lot. And then additionally, it's possible that the columns can be rebuilt, but with the siding that's currently on the house, which one of the commissioners said she thought looked fine. And the wall will be stuccoed as well. That's something that is going to take place.
And Ms. Najee, I suppose I understand that your hands are tied because this is a Landmarks Commission decision. It's not a recommendation technically. It's a decision of the Landmarks Commission, which I should point out, Ms. Najee, in their decision, there's some language that notes that this is a recommendation. That's confusing in itself. I would suggest that the Landmarks Commission go back and change their boilerplate forms to state that this is a decision, an appealable decision or something to that effect, rather than a recommendation, because I think that is confusing. And they shouldn't reference Article 12 anymore. That would have been an error in my. I understand. I totally understand. Errors happen, and I do think it's a minor error, but it's something that should be looked at. Okay, great. Ms. Marion, do you have any rebuttal?
No, I don't have anything to add to that, but I do want to just add for the record that the commissioners, their terms had expired by the time that this hearing took place, and it was not a hearing that immediately needed to happen. It could have waited until new commissioners were appointed. And so I think for the record, it's important to note that it was also not clearly announced at the hearing that they were continuing their duties outside of their term.
Now, I looked at that because I saw that in the appeal, and under the city ordinance, there is a specific provision that allows commissioners to continue until they are replaced by the city council or until their term until they are reappointed by the city council, essentially, or replaced by the city council. So they're allowed to continue in the same capacity until the city council deals with it. And that ordinance provision is section, I think it's Article 2, somewhere in Article 2.6. But it's
right.
Okay.
That's our understanding as well, but we do not agree that they should have continued forward with a hearing of such importance when their term was expired, when new commissioners were soon to be appointed.
Okay. Okay, I get it. Thank you. Is there anything else you would like to add?
I have nothing further.
Okay, good. I will have a recommendation to the city council within 15 days. I will send it to council and to all the parties that were on the email chain simultaneously within 2 weeks. Okay.
All right, wonderful. Thank you so much.
Thank you, folks. I appreciate it. Thank you, Miss Marion. You did a great job. And say hello to Miss McGinn. I'm one of her fans. Excuse me, sir. Who are you?
Hi. So my name is Ben Sturge. So
Sturge, hold on. Who are you?
So I am on the board of the Huning Highland Historic District Association. And so
hold on, wait. I can't allow you into this hearing. You can observe the hearing, but you can't testify because nobody has called you to testify in this hearing. Yeah, this is I'll explain it. I apologize. I'm sorry. It looked like you were waiting patiently for this process.
Well, I didn't know whether I was going to speak or not, but I did.
Right, Mr. Stewart. Yeah, this is a quasi-judicial hearing on the record. And so unless a party calls you as a witness, I can't allow you to testify because we're not rehashing something. I'm not stepping into the shoes of the Landmarks Commission and reconsidering the issues. I'm determining whether or not the Landmarks Commission erred. And so
so the association misunderstood.
Yeah, the association should have presented at the Landmarks Commission, or somebody could have called you as a witness in this hearing.
Right.
They did not.
Okay. So, got it. Yeah.
My apologies, sir. I know you
no.
patiently and quietly. Thank you so much.
Yeah.
Okay. Thank you, folks. Bye-bye.
Thank you.